In Part 1, name of the country and its boundaries has been defined. In Part 2, the citizens were given citizenship. Now it's time to give fundamental rights to the citizens of India, which is defined in Part 3 of the Indian Constitution. Part 3 of Indian Constitution is also known as Magna Carta of India. Magna Carta is the first ever written document on fundamental rights of the citizens issued by King John of England in the year 1215. Part 3 of Indian Constitution talks about the same thing, that is fundamental rights of citizens. That's why we adopted the name Magna Carta. Fundamental rights are defined as the basic human rights of all citizens, irrespective of race, caste, religion, gender, place of birth, etc. The idea of fundamental right is taken from American Constitution. Fundamental rights are justiciable and they are protected and guaranteed by the Supreme Court. It means if someone violates your fundamental right, then you can move to the Supreme Court against that entity. Fundamental rights can be suspended during national emergency except Article 20 and Article 21. Article 20 talks about protection of conviction for offences and Article 21 is about protection of life and property. These two articles cannot be suspended in any condition. Part 3 of Indian Constitution is defined under Article 12 to Article 35. Originally, Indian Constitution provided 7 fundamental rights. Right to equality, right to freedom, right against exploitation, right to freedom of religion, cultural and educational right, right to property, right to constitutional remedies. However, right to property was removed from the list of fundamental rights during 44th Amendment Act of 1978. So now we have total 6 fundamental rights. When we will study about these fundamental rights, we will come across a word state several times. So the first article of Part 3, that is Article 12, defines the word state. It says, the Constitution of India not only gives fundamental right to the citizens but also imposes duty on the state to ensure that the fundamental rights are protected. In case fundamental rights are violated, it can only be claimed against the state. So it is very important to understand what bodies fall under the definition of a state. So it includes Central Government and Parliament of India, State Government and State Legislature, local authorities like municipalities, municipal corporation, Nagar Palika, Zilla Panchayat, etc. and statutory and non-statutory bodies like National Human Rights Commission, Central Bureau of Investigation, etc. All these bodies represent state. Next is Article 13. To understand Article 13, first we need to know that when our fundamental rights was created and since when did we start using it. Fundamental rights were introduced at the time of the commencement of the Constitution, that is 26 January 1950. Now Article 13 contains 4 clauses. Clause 1 says, even before the implementation of fundamental rights, there were many laws in our country. But after the implementation of fundamental rights, some previous laws were violating the fundamental rights of the citizens. So Clause 1 of Article 13 clarified that all such laws which will not violate fundamental rights will remain same as before, but all such laws which will violate the fundamental rights will be declared null and void by the Supreme Court. Clause 2 of Article 13 says that after the commencement of the Constitution, that is 26 January 1950, the state will not make any such law which will violate the fundamental rights of the citizens. Next is Clause 3 of Article 13, which defines the word law, which we have been using again and again in Clause 1 and Clause 2. So Supreme Court mentioned the law enacted by Parliament and State Legislature, temporary laws and ordinances issued by President or State Governor, and delegated legislation, which means giving power or authority to someone lower than his rank to make laws. All these entities come under the definition of a law. Now the last clause, that is Clause 4 of Article 13. Clause 4 was not in our Constitution earlier. It was included in 24th Amendment Act of 1971. Why was there a need to include Clause 4 in Article 13? According to Article 368, Parliament has power to make changes in the constitution, but Parliament comes under the definition of a state, and Clause 1, 2 and 3 of Article 13 restrict states to make such laws which can violate fundamental rights of a citizen. So Parliament thought that its lawmaking power was being curtailed, and that's the time when Parliament passed 24th Amendment Act to add Clause 4 in Article 13, which says, "Nothing in this article shall apply to any amendment of this Constitution made under Article 368." It means whatever amendment Parliament will do under Article 368 cannot be challenged under Article 13. So today we discussed about Article 12 and 13 in detail. In the next video, we will talk about the first fundamental right, that is right to equality, defined under Article 14 to 18.